invalid caste certificates from getting benefit, but we can't have a general PI like this.
Issue is about when the similar issue decided by the Honorable High Court. The reasoning given by the High Court is very important.
But the danger, look at it this way. Suppose 200 people in Maharashtra have been given the benefit of protection of their services, notwithstanding that their caste certificates were invalid. We can't just, those people are not parties, we don't know how many people are there.
Issue is not about the lordships. This is not a personal issue against any individual. This is about the state of Maharashtra government resolution. If the judgment passed by this honorable court, whether this honorable government of
दोस्तों यहाँ पे सुप्रीम कोर्ट की तरफ से आज आप लोग की सुनवाई जो है नीट यूजी 2024 के पोस्टपोन एग्ज़ाम के जो रीनीट करवाने के लिए बात चल रही है उस पर फाइनल डिसीजन आज आने वाला है। देखते हैं क्या आज फाइनल डिसीजन आप लोग का रीनीट के ऊपर आता है या फिर एग्ज़ाम को कैंसिल किया जाता है। अभी यहाँ पे सुप्रीम कोर्ट में बात चल रही है कि क्या आप लोग का रीनीट दोबारा से कनेक्ट करवाना चाहिए या फिर नहीं करवाना चाहिए।
Vague and general. Why don't you move the High Court? I'll tell you why. You may also have to implement. If there are say specific people, or if you're challenging a geo, you may have to challenge that geo. You have not challenged the geo.
That's what I'm pointing out. Just Lordship, kindly see the page number 123. While deciding the similar issue, what contention decided by the Honorable High Court. Kindly see the page 123. The reasoning given by the High Court of petition.
In some other case?
No, same case. Yes, the issue is about those persons who failed to approve the caste certificate. They approached to the High Court, and while deciding the same issue, just see the reasoning.
Just 1 second.
Page 123.
What annexure will that be? Wishing all the members of the bar a very good term. We have one judgment which I'll just pronounce. And one second. I will deliver the judgment and I'll hear you after that. We're just delivering a judgment. The certification of the film in question is not an issue before us. In that regard, as the High Court has noted, the appellant has not contested Sony Pictures' reply to the legal notice. During the course of the hearing, it was stated across the bar that since the film has been released in the meantime, the certification itself is not seriously in challenge. The appellant has sought the framing of guidelines and inclusion of recommendations for creators to follow while dealing with sensitive subjects such as the rights of persons with disabilities in the visual media. We have a section called Stereotyping as an Antithesis to Dignity and Non-Discrimination. This court is cognizant of the impact of stereotypes on discrimination and the enjoyment of fundamental rights. We have traced safeguards against stereotyping to the Anti-Discrimination Code under Article 15, the right to dignity and the right to equality. Recent rulings reflect the judiciary's evolving role in not only safeguarding individual rights, but also in addressing complex intersections of disability, gender, and mental health, enriching the discourse on equality. This perspective rejects a one-size-fits-all approach, acknowledging that disability is a nuanced, individualized concept shaped by factors such as mental impairment and personal circumstances. The legal framework stresses the need to prevent stigmatization and discrimination against individuals with disabilities, recognizing the profound impact on the sense of identity and dignity. In the context of historically oppressive representation of persons with disabilities, speech that entrenches stereotypes is opposed to the dignity of such individuals. However, not all speech that uses stereotypes commonly employed against persons with disabilities is abhorrent by reason of such use alone. As stated in the preceding section, the context, the intention, and the overall message must be considered.
What if I had started a mutual fund SIP of rupees 5,000 per month 25 years ago?
Make jokes at the expense of persons with disabilities and to use them for comic relief. Also, the medical model treats disability as a personal tragedy, which is by definition incompatible with humor. This understanding is now obsolete under the social model, which views disability as a function of social barriers that disable such individuals. The social model says that stereotypes stem from a lack of familiarity with disability. This lack arises due to inadequate representation and participation of persons with disabilities in dominant discourse. Despite the history and the obsolescence of the medical model, humor is not universally denounced in the context of disability. We must therefore distinguish disabling humor that demeans and disparages persons with disability from disability humor, which challenges conventional wisdom about disability. While disability humor attempts to better understand and explain disability, disabling humor denigrates it. The two cannot be equated in their impact on dignity and on stereotypes about persons with disabilities. Since the issue involves the fundamental rights of persons with disabilities, we take this opportunity to provide a framework of the portrayal of persons with disabilities in the visual media that aligns with the anti-discrimination and dignity-affirming objectives of the Constitution, as well as the Rights of Persons with Disabilities Act. We are cognizant that Article 19.2 is exhaustive of the limitations that can be applied in the freedom guaranteed under Article 19.1a. The framework we wish to lay down is in line with our findings in Vikash Kumar, where we emphasize that the fundamental rights under Part 3 of the Constitution apply with equal rigor to persons with disabilities. The language of our discourse ought to be inclusive rather than alienating. We noted in Vikash Kumar that insensitive language was contrary to the dignity of persons with disabilities. As long as the overall message of the film justifies the depiction of disparaging language being used against persons with disabilities, it cannot be subjected to restrictions beyond those placed in Article 19.2. However, language that disparages persons with disabilities marginalizes them further and supplements the disabling barriers in their social participation without the redeeming quality of the overall message of such portrayal and must be approached with caution. Such representation is problematic, not because it offends subjective feelings, but rather because it impairs the objective societal treatment of the affected groups by society. We believe that representation of persons with disabilities must regard the objective social context of their representation and not marginalize persons with disability. And we have now laid down some guidelines, which I'll just read out a few and then continue. 1. Words cultivate institutional discrimination. Terms such as cripple and spastic have come to acquire devalued meanings in societal perceptions about persons with disabilities. They contribute to the negative self-image and perpetuate discriminatory attitudes and practices in society. 2. Language that individualizes the impairment and overlooks the disabling social barriers, for example, terms such as afflicted, suffering, and victim, should be avoided or adequately flagged as contrary to the social model. 3. Creators must check for accurate representation of a medical condition as much as possible. The misleading portrayal of what a condition such as night blindness entails may perpetuate misinformation about the condition and entrench stereotypes about persons with such impairments, aggravating the disability. Visual media should strive to depict the diverse realities of persons with disabilities, showcasing not only their challenges but also their successes, talents, and contributions to society. 6. They should neither be lampooned based on myths. People bump into objects in their path, nor presented as super cripples on the other extreme. This stereotype implies that persons with disabilities have extraordinary heroic abilities that merit their dignified treatment. For instance, the notion that visually impaired persons have enhanced spatial senses may not apply to everyone uniformly. It also implies that those who do not have such enhanced superpowers to compensate for the visual impairment are somehow less than normal or ideal. 7. Decision-making bodies must bear in mind the values of participation. The nothing about us, without us principle is based on the promotion of participation of persons with disabilities and equalization of opportunities. It must be put to practice in constituting statutory committees and inviting expert opinions for assessing the overall message of films and their impact on dignity of individuals under the Cinematograph Act and rules. The Convention on the Persons on the Rights of Persons with Disability, the Convention on the Protection of Rights of Persons with Disabilities, also requires consultation with and involvement of persons with disabilities in the implementation of measures to encourage portrayal that is consistent with it. Collaboration with disability advocacy groups can provide invaluable insights and guidance on respectful and accurate portrayals, ensuring that content aligns with the lived experiences of persons with disabilities. And then we have referred to training and sensitization programs. So we will lay down a comprehensive framework of hopefully what portrayal in the visual and electronic media should be like, without infringement on the right under Article 19(1). Thank you very much for your assistance, everyone.
It's a path-breaking judgment. You are the petitioner. I am privileged to be a part of this judgment.
You also made your submissions at the course of the hearing. Thank you very much.
Thank you so much for this, sir. Thank you.
Correct.
Much of this, Lord. May I crave my Lord's indulgence on this?
Yes.
Manish Sisodia's matter, he's been there 16 months in jail. The court said trial must be near conclusion. It hasn't started. I filed the SLP. They gave liberty after third. The Supreme Court gave liberty to list it.
On Saturday, so the defects will be cured.
It's a revival because the court said you just keep it in abeyance, revive it. Lordship, I kindly look into it.
Yeah, look into it.
You've given the email. The second matter, I'm not troubling. Lordship is showing 23rd. The second matter, 23rd is showing just now. So we'll just say not to delete. There's one more.
Just see what it is. Have you sent an email?
Yes, yes. Please here.
I'll attend to it the moment we write.
It's already showing 23rd in the second matter. So it's just not deleting.
If an email is sent, then I say not to be deleted. I even have a code. I call it NTD, not to be deleted. So we'll do that in the answer.
I have a question because we have circulated emails. This is a matter of some urgency. Your lordships have issued notice. There's an interlocutory order. The matter is now for final disposal, my main appeal. But there's a need for urgent further interlocutory relief because I've been outflanked. I don't want to take it.
Make sure that
Could it come up on Monday, Manoj, next Monday?
I'll immediately attend to it.
I'm very grateful.
Yes.
Not in the matter, my lord, where I had this urgency, I had moved, my lord, the vacation to. My lord, the lordship said that I have to move the learned chief justice first, which I have done. I sent her, my lord, I made a mentioning memo. Now, my lord, apparently,
I think all requests by Saturday evening. If there's something which has remained, I'll do it today itself.
It's just that, my lord, that we moved the registrar. The registrar said the orders of the chief justice are required. It's now listed on 12th is a day, my lord. All that we pray for is that it should not be deleted.
I'll look at it. Yes.
Let it not be deleted, my lord. That's all.
Let me just see what it is. I'll process it the moment we rise.
Well, as a 30-mile petition filed by 6 students from Gujarat, we are praying that the NEET exam should not be cancelled. The lead matter is coming up at item 31 today.
That's all I just mentioned when the matter is.
Very well.
Yes.
May I say the lordship, sir?
Yes.
Lord, a TV channel in Bangalore has been restrained from broadcast completely last Wednesday. We have filed SLP, gave the diary number. We mentioned to the registrar this morning, but it could not be mentioned earlier.
Just circulate an email.
Tomorrow, day after.
Just circulate an email. It will be listed, but just when was the email packet? Then why do you not have to mention?
This morning.
I'll persuade on the outcome.
Wednesday.
Don't worry. It will be attended to today. It will be attended to right away.
One lady petitioner, she is a widow. If Madras High Court granted bail, there were certain conditions, my lord. A cheat fund. Her husband committed suicide because.
Circulate, Mr. Mishra, circulate an email. I'll do it custody today.
Lord, they are going to take custody. Lord,
send an email. The moment I rise at 1 o'clock, I'll attend to it.
Lord, listing registrar has allowed it in the morning today.
All right. Just point it out to me. We'll immediately I'll attend to it.
My lord, my case was in the advance list tomorrow, but not in the main. My lord, my case was
matter pertain to Justice Bopanna's roster.
Yes, my lord.
The registrar informed me I've already reallocated it to another judge. Now that Justice Bopanna has retired, it will come up next week. It's coming up next week.
Lordship, similarly, this is the case, again, in the advance list, this is with respect to the rights of people with wheelchair, the SOP at airports, that learned SG has said he's ready to cooperate. It's just been coming but not listing.
Just circulate an email, I'll immediately list.
Thank you so much.
Yes.
I'm giving you 5 minutes, Lord. You have finished. Planting that tree, Lord. This is going to
No, you can't mention for planting a tree in the Chief Justice Court. You have to then tell. All right. All right. One second. Before we begin, just a couple of housekeeping announcements for the members of the bar. The space in front of courtroom numbers 1, 2, 3, Chief Justice Court 2, 3, 4, and 5 is being completely air conditioned for the convenience of the members of the bar and the litigants. We've been in touch with some of the most leading agencies in the country who are specialized in that because it's a heritage building. Delhi Urban Arts Commission, the IIT, we have gone to IIT Delhi to ensure that the design is secure, safe. Work is going on. I'd expected that it will be completed by the end of the vacation. It's taking a little longer, maybe a few more, maybe a week or so. There'll be a little inconvenience to the members of the bar. So I request you to please excuse us for the inconvenience and bear with it for about a week or so. We'll be completely air conditioning that so that you people you don't have to go out of the court and walk into the heat there. So that corridor is being second. So I request all of you to bear with the inconvenience for a little while. The second, there were 2 waiting rooms just next to the grand staircase, which was set up during COVID. I thought that they were really just makeshift, and lawyers were using them in very large numbers. So during the vacation, those courtrooms, those 2 waiting rooms have been completely restored. They have been made in a manner which would match with the facade of the Supreme Court. So you can all start using it again and wait for your matters in comfort over there in those 2 rooms. The third, we have now expanded facility for the registrar's court. And there will be a full-time registrar who will be working in that court right from Monday to Friday during court hours instead of having rotations and sporadic assignments for registrars to be in that court. So there'll be a full-time registrar's court.
दोस्तों यहाँ पे आप लोगों ने सुप्रीम कोर्ट की लाइव हियरिंग देखी। अभी यहाँ पे बेंच होने वाली है। आप लोग क्या लगता है कि रिनीट दोबारा से होना चाहिए या फिर नहीं होना चाहिए? कमेंट करके एक बार चैट बॉक्स में सभी लोग बता दीजिए। दोस्तों जो भी लोग यहाँ पे ज्वाइन हो रहे हो, एक बार सभी लोग चैट बॉक्स में बता दो कि रिनीट दोबारा से कनेक्ट करवाना चाहिए या फिर नहीं करवाना चाहिए। अभी के लिए यहाँ पे हियरिंग जो थी वो आप लोगों ने स्क्रीन पे देखी होगी।
It was not listed because it is a old matter. Regarding a PGI admission matter.
I'll list it, yes.
Finance. May I mention?
Just circulate an email and I'll attend to it in the afternoon today. Circulate an email and I'll get your matter listed as quickly as possible. All right, let's see the best day.
My lord, may I mention item 40? My lord, by the time the matter reaches on board, my lord, NTA can be directed to produce the original OMR of the
Just not wait for the matter to reach. Yes, item 1.
Please, my lord. In item 1, this is a bail plea, my lord. The petitioner is in custody since 10th of February 2022.
in possession. You were alleged to be in possession of 80 kilograms.
I was not found in the location.
You are not. You are. They say that your identity cards were found in the vehicle.
No, you're not the identity card, Miller.
You're not the registered owner of it.
I'm not the registered. I have placed it on record, Miller. The registered owner says in his cross-examination, he has been cross-examined.
The allegation is that the vehicle has been transferred in your favor.
He says, but in the cross-examination, he says he cannot confirm if the vehicle that has been alleged to be found by the police is the same vehicle which he sold to me, even otherwise, my lords.
All I will issue notice here and keep it after 2 weeks. Serve the standing counsel for the state of Madhya Pradesh.
I'm most grateful.
Issue notice, returnable on liberty to serve the standing counsel for the state of Madhya Pradesh. You've been denied, Antonio.
I'm most grateful, my lords.
Item 2.
Very short question is what is the
There's a
relevant?
delay of 235 days.
There is a delay, my lord, because
Why
of
should
the
we condone that email?
my lord, there was
And look at it this way. When they first filed their claim before the tribunal in Madhya Pradesh, you objected to the jurisdiction of the tribunals, relying upon the judgment in VA Tech. True, the judgment in VA Tech has been overruled subsequently. But at that stage, at your behest, you were sent to the arbitrator. You didn't object to his
by the
jurisdiction
High
to the arbitrator.
by the Honorable High
Right.
Court.
But then you never objected before the arbitrator. Now there's an award.
It's a matter of record that we objected only at the stage of 37, my lord. I cannot quarrel with that.
And we'll dismiss it. What we'll do is we'll dismiss it on the ground of limitation, so that it doesn't become a precedent in any other case. And
Question
it's a
of
question
law.
of law open. There's a delay of 235 days in filing the special petition against the judgment of the Madhya Pradesh High Court dated 9 December 2022. Full stop. There is no satisfactory explanation for the delay. Full stop. Hence, the petition is dismissed on the ground of delay. However, we clarify that since the bar of limitation has intervened, it has not become necessary for this court to express any opinion on the question of law raised.
It will remain